You're nothing but a troublemaker from the projects. Look at me when I'm sentencing you, Judge Harrison barks. The gavel crashes down as 17-year-old Tiana stands frozen before him. The all-white courtroom audience snickers. Judge Harrison descends from his bench, invading her personal space. He snatches her court documents, letting them scatter across the floor. Pick them up, now. His shoe taps impatiently as she kneels to gather the papers. Her public defender remains silent, eyes averted. Remember your place, Harrison sneers, strutting back to his position of power. Tiana's jaw tightens. She grips her small notebook like a shield against her chest. The notebook in her trembling hands contains evidence that will obliterate Harrison's career within hours. Dawn breaks over the county courthouse. Tiana adjusts her modest blue blouse, the nicest one she owns. Her father, James, walks beside her, his maintenance uniform freshly pressed. They couldn't afford to miss work, but they couldn't afford a private attorney either. "Remember what I told you," James whispers. "Stand straight. Speak clearly. Look them in the eye." Tiana nods, clutching her notebook. Inside, pages of careful observations fill the margins. She's been preparing for weeks. Their assigned public defender, Mr. Walsh, meets them in the hallway. He shuffles through his overflowing case files, finally locating Tiana's paperwork. "Davis. Tiana Davis. Right. The hotel trespassing." Walsh barely makes eye contact. "Judge Harrison's courtroom today. Look, you should take the plea deal. First offense. Well, technically second if we count that park incident." "But I wasn't," Tiana begins. Walsh cuts her off. "Harrison is tough on, well, people like you. Take the deal. Community service beats juvenile detention." Across town, Judge William Harrison adjusts his silk tie in the mirror of his Westlake mansion. His wife places his coffee precisely where he expects it. "Juvenile cases today," he complains, checking his Rolex. "Delinquents wasting the court's time. There's one about trespassing at the Grand Hotel." He pulls out his phone and speed dials. "Charles, Bill Harrison, about that trespasser at your hotel. Don't worry, I'll make an example of them. Can't have people thinking they can walk into establishments where they don't belong." Back at the courthouse, Tiana sits quietly, observing the proceedings before her case. A white teenager caught shoplifting receives a stern warning and 20 hours of community service. Another white defendant with vandalism charges gets a reduced fine after his father speaks to the judge. Then a black teenager appears, charged with loitering. Harrison's demeanor transforms instantly. His voice becomes cold, condescending. The sentence, maximum community service and a substantial fine. Tiana's hand moves quickly across her notebook page. Her observations grow more detailed with each case. As the bailiff calls Davis Tiana, a sharp-eyed woman in the back row sits forward, her attention locked on Judge Harrison. Tiana approaches the defendant's table, steps measured and deliberate. Judge Harrison barely looks up from his papers, a dismissive frown forming at the corners of his mouth. "Another trespassing case," he sighs dramatically. "Seems to be an epidemic of young people thinking they can go wherever they please." Mr. Walsh clears his throat. "Your Honor, my client is a first-time offender in this context. We're prepared to discuss a reasonable penalty." "Second-time offender," Harrison interrupts, tapping a folder. "I see a prior incident at Westside Park after hours." "I was studying," Tiana says quietly. "The lights at home went out again. The park has benches under streetlights." Harrison's eyebrows rise. "Did I ask you to speak?" "Mr. Walsh, control your client." The prosecutor stands, straightening his tie. "Your Honor, the defendant was discovered in a restricted area of the Grand Hotel, specifically near the executive conference rooms where valuable equipment is stored. Security footage confirms she had no legitimate business there." "What do you have to say for yourself?" Harrison addresses Tiana directly now, leaning forward. "I was there for a program," she begins. "A program?" Harrison scoffs. "The Grand Hotel doesn't run programs for..." He stops himself, but his implication hangs in the air. "Your Honor," Walsh interjects weakly, "perhaps a fine and standard community service would—" "Mr. Walsh, this court takes trespassing in upscale establishments seriously. It begins with trespassing, ends with theft." Harrison's gaze slides over Tiana's neat but modest clothing. The defendant has already shown a pattern of being where she doesn't belong. Tiana's father shifts in his seat, knuckles white against his knees. A court officer steps slightly closer to him in warning. Throughout the exchange, Tiana writes in her notebook, her pen moving steadily across the page. Harrison notices. "What are you writing?" he demands suddenly. Tiana looks up, startled. "Just notes, Your Honor." "Hand it over." Harrison extends his palm. "This is my courtroom, not your classroom." Tiana hesitates, then slowly passes her notebook forward. The bailiff takes it to Harrison, who flips through the pages with growing irritation. Harrison's mocking smile falters when he sees detailed documentation of his courtroom patterns, complete with dates, quotes, and statistical notations. Harrison's face tightens momentarily before his practiced judicial mask returns. He snaps the notebook shut and tosses it back toward Tiana with exaggerated disdain. "Quite the little researcher, aren't we?" he sneers. "Taking notes won't change the facts of your case." He leans back, fingers steepled beneath his chin. "I've decided that a standard community service arrangement is insufficient here. Ms. Davis clearly has an attitude problem that needs addressing." Walsh starts to object, but Harrison silences him with a raised hand. "Stand up, Ms. Davis," Harrison commands. "Come to the center of the courtroom." Tiana rises slowly, uncertainty in every movement. The courtroom watches as she steps forward, standing alone on the cold marble floor. "Now," Harrison continues, satisfaction creeping into his voice, "I want you to explain to everyone present why you thought you belonged in a five-star hotel like the Grand. What possible legitimate reason could you have?" "I was invited to—" Tiana begins. "Speak up," Harrison barks. "The court reporter can't hear your mumbling." Tiana swallows hard. "I was invited to participate in a program." "A program," Harrison repeats, drawing out each syllable for the audience's benefit. "And who exactly invited you to this mysterious program?" "The National Merit Scholarship." Harrison laughs, cutting her off. "The National Merit Scholarship Program doesn't meet in hotel conference rooms. They meet in schools, universities." He addresses the courtroom directly. "Creative. I'll give her that." Whispers ripple through the spectators. Tiana stands perfectly still, her face a careful mask hiding the humiliation burning beneath. "Turn around, Ms. Davis," Harrison instructs. "Let everyone see your idea of appropriate courtroom attire." Tiana hesitates. "That wasn't a suggestion," Harrison snaps. She turns slowly in a circle, her simple blue blouse and dark skirt modest and clean, if not expensive. "Your Honor," Walsh finally speaks up, "this is highly irregular and potentially—" "Mr. Walsh, are you questioning my methods?" Harrison's voice drops dangerously. "Because I can hold you in contempt as easily as your client." Walsh subsides immediately. Harrison lifts his phone. "I have Charles Whitfield, owner of the Grand Hotel, on the line." "Mr. Whitfield, was there any educational program scheduled in your conference rooms on Tuesday afternoon?" A tinny voice responds through the speaker. "Absolutely not, Your Honor. Our conference center is exclusively for business clients and hotel events. Security reported the young woman near our Platinum Suite, where we keep valuable equipment." Throughout this exchange, the woman in the back row continues observing, her tablet now recording every word. Two well-dressed individuals slip in beside her, conferring in hushed tones. Tiana stands alone in the center of the courtroom, back straight despite the public humiliation. A single tear threatens at the corner of her eye, but she blinks it back fiercely. "Thank you, Mr. Whitfield," Harrison concludes the call. "The court appreciates your time." He turns his attention back to Tiana. Still maintain you were there for a program? Yes, Your Honor, she answers, voice steadier than before. Defiant to the end, Harrison sighs theatrically. Tiana's phone buzzes in her pocket. She doesn't reach for it. The screen flashes briefly with a message. Hold steady, justice incoming. You're not alone. Court will recess for 15 minutes, Harrison announces abruptly. Ms. Davis, don't leave the building. We're not finished with your case. The bailiff calls for all to rise as Harrison exits. The moment he's gone, whispers erupt throughout the courtroom. Tiana returns to her seat, face carefully composed despite the humiliation still burning in her chest. I need to use the restroom, she whispers to her father. James nods, concern etched in every line of his face. You're handling this with more strength than I could, he says softly. I'm proud of you. Tiana slips away, finding refuge in the courthouse bathroom. Only there, in a locked stall, does she allow herself a moment of vulnerability. Silent tears stream down her face as she grips the edge of the sink, knuckles white with tension. She splashes cold water on her face, erasing the evidence of her tears. The bathroom door swings open. Tiana straightens, composing herself. A black woman in her 40s enters, dressed in an impeccable charcoal suit. She's the same woman who was watching from the back row. Tiana Davis? She asks, voice low and confident. Tiana tenses. Yes? Dr. Olivia Bennett, Educational Director for the National Merit Scholarship Program. She extends a business card with the organization's embossed logo. I believe we had an appointment at the Grand Hotel that was interrupted. Recognition flashes across Tiana's face. Dr. Bennett? But the hotel owner said, Charles Whitfield doesn't personally manage conference bookings, Bennett explains. Our event was arranged through their corporate office, not the local management. We booked the same space quarterly through their diversity initiative program. She leans against the counter. I must apologize for not intervening sooner. When you didn't arrive for your interview, we investigated. What I've witnessed today is disturbing, but not, unfortunately, surprising. Bennett gestures toward Tiana's notebook. Your documentation of Harrison's behavior caught our attention. We've received similar reports from other minority students over the past year. Meanwhile, in his chambers, Harrison loosens his tie and answers his private line. Bill, it's Senator Grayson. Wanted to give you a heads up. Judicial review appointments are coming up next month. There's been some chatter about diversity on the bench. Harrison laughs. Political correctness gone mad. Don't worry about me. 20 years on this bench, and no one successfully challenged my rulings yet. Still, might want to tread carefully, Grayson warns. Actually handling one of those cases now, Harrison replies. Another delinquent who needs to learn respect for private property, making an example of her as we speak. Back in the bathroom, Dr. Bennett makes several calls in rapid succession. First to the hotel's corporate headquarters, confirming the scholarship program booking. Next to the State Judicial Review Board, speaking in clipped, urgent tones. Yes, it's happening exactly as reported, she says. We're witnessing it firsthand. She listens briefly. Understood. Everything's being documented. Her final call is to a senior partner at Marshall & Reed Law Offices. Thomas, Olivia Bennett. We need that pro bono representation we discussed. Today. Right now, actually. She turns to Tiana. We've been building a case against Harrison for months. Your detailed notes provided exactly the pattern evidence we needed, but we required clear documentation of his behavior in court. The bathroom door opens again. James enters cautiously. Tiana, are you okay? Dr. Bennett introduces herself, quickly outlining the situation. Mr. Davis, your daughter was legitimately at that hotel for a scholarship interview. Judge Harrison's treatment of her today is part of a documented pattern of discriminatory behavior from the bench. James's expression shifts from confusion to determination. What do we do? Return to the courtroom. Tiana needs to remain composed no matter what Harrison says or does. The truth will come out, but timing is crucial. Tiana takes a deep breath. I can do this. As they prepare to return, Tiana notices the badge clipped to the lanyard of Bennett's colleague who has just joined them. The insignia reads, Governor's Ethics Commission, Special Investigation Unit. The woman catches Tiana's eye and taps her tablet deliberately, confirming that every word, every action in that courtroom is being recorded. Court resumes with a sharp bang of Harrison's gavel. His mood appears to have darkened during the recess, his mouth set in a tight line as Tiana returns to her place at the defendant's table. After consideration, Harrison announces without preamble, I've determined an appropriate penalty for Ms. Davis's offense and continued dishonesty. He shuffles papers for dramatic effect. The defendant will write a public apology to be published in the county newspaper, acknowledging her trespassing and dishonesty before this court. Additionally, she will complete 200 hours of community service. A ripple of surprise passes through the courtroom at the unusually harsh sentence. Furthermore, Harrison continues, satisfaction evident in his tone, that community service will be performed at the Grand Hotel itself. Perhaps cleaning bathrooms will teach a more lasting lesson about respecting private property than empty words could. Walsh shifts uncomfortably. Your Honor, that seems excessive for a first-time. Second offense, Harrison corrects sharply, and given the defendant's attitude, I believe it's entirely appropriate. Do you wish to object formally, Mr. Walsh? Perhaps risk a contempt citation yourself? Walsh deflates visibly. No, Your Honor. Very well, then. Objection. The word cuts through the courtroom. All heads turn as a tall man in an expensive suit rises from the back row and strides forward. Thomas Reynolds, Your Honor, Marshall and Reed Law Offices. I'll be taking over Ms. Davis's defense, effective immediately. Harrison's face flushes. This is highly irregular, Mr. Reynolds. We're in the middle of sentencing. Which is precisely why I'm intervening now, Reynolds replies smoothly, placing his credentials before the court. My motion to substitute as counsel has already been filed with the clerk. Since no formal sentence has been entered into the record, we're well within procedural bounds. Harrison examines this paperwork, searching for any technicality to refuse it. Finding none, he nods curtly. Fine. Mr. Walsh, you're excused. Walsh gathers his papers, relief evident as he retreats. Reynolds wastes no time. Your Honor, the defense moves that all charges against Ms. Davis be dismissed immediately due to lack of evidence and improper procedure. Denied, Harrison snaps. Then I must inquire, Reynolds continues calmly, why Ms. Davis's case is receiving such unusual treatment compared to similar cases heard earlier today. Harrison's knuckles whiten around his gavel. Each case is unique, Counselor. Indeed, Reynolds agrees, producing a folder, which is why I've taken the liberty of reviewing your court records for the past 6 months. There appears to be a statistical anomaly in sentencing patterns based on defendant characteristics. Are you accusing this court of impropriety? Harrison's voice rises dangerously. I'm simply entering facts into the record, Your Honor, Reynolds replies. More observers enter the courtroom quietly, some taking notes, others watching Harrison intently. I'll hold you in contempt, Harrison threatens. Your Honor, Reynolds says with unruffled calm, I request that the court record reflect your hostility toward the defense's legitimate inquiry. Would you like to explain, Reynolds asks softly, why the defendant's legitimate reason for being at the hotel wasn't verified before this proceeding began? Harrison straightens in his chair, jaw working beneath flushed skin. The courtroom falls silent, spectators leaning forward in anticipation. The owner of the Grand Hotel verified no such program existed, Harrison states flatly. His word is sufficient for this court. Is it? Reynolds removes a document from his briefcase. I submit as evidence confirmation from the Grand Hotel's corporate events office, documenting that the National Merit Scholarship Program reserved the Oakwood Conference Room from 2 o'clock to 5 o'clock p.m. on the date in question. He approaches the bench, offering the document. Harrison takes it reluctantly, eyes scanning the official letterhead. Furthermore, Reynolds continues, Ms. Davis was there by specific invitation, as evidenced by this email from Dr. Olivia Bennett, educational director of the program. The prosecutor rises hesitantly. Your Honor, the state wasn't provided with this evidence. Because no one bothered to investigate, Reynolds responds. The defense shouldn't have to prove innocence when the prosecution hasn't established guilt. Harrison's phone rings. He answers it on speaker, maintaining the pretense of judicial authority. Mr. Whitfield, were you aware of any National Merit Scholarship event at your hotel last Tuesday? Whitfield's voice sounds less certain now. I don't personally handle all bookings, Your Honor. The corporate office sometimes arranges events without my direct involvement. So you testified earlier without complete knowledge? Reynolds interjects. Objection, the prosecutor calls out. Sustained, Harrison says quickly. Mr. Reynolds, you will not interrogate witnesses without permission. More officials enter the courtroom. A woman with a State Bar Association badge takes a seat in the front row, notebook open. Harrison notices the growing audience, sweat beading at his temples despite the courtroom's air conditioning. He tugs at his collar, attempting to regain control of the proceedings that are rapidly slipping away. The court will take these new documents under advisement, Harrison announces. However, this last-minute evidence appears designed to ambush the court and the prosecution. With respect, Your Honor, Reynolds counters, proper investigation would have revealed these facts before Ms. Davis was publicly humiliated. One phone call to verify her story would have sufficed. Harrison turns his frustration toward Tiana. The defendant should have spoken up more clearly about her alleged appointment. Your Honor, Reynolds says, voice hardening for the first time. Ms. Davis attempted to explain multiple times. Court transcripts will show you interrupted her repeatedly and dismissed her explanations without consideration. The mood in the courtroom shifts palpably. Spectators exchange glances, some nodding in recognition of the truth being spoken. The prosecutor busies himself with papers, clearly distancing himself from Harrison's approach. Harrison checks his watch with theatrical impatience. This court's time is valuable, Mr. Reynolds. We can't afford to waste it on prolonged discussion of a simple trespassing case. Reynolds maintains perfect composure, hands clasped before him. The contrast between his professional demeanor and Harrison's increasing agitation becomes more pronounced with each exchange. Speaking of time, Your Honor, Reynolds says evenly, perhaps you could explain why cases involving minority defendants consistently receive more of your valuable court time than those involving white defendants? How dare you? Harrison explodes, slamming his gavel with such force that the sound echoes like a gunshot through the courtroom. This is contempt of court. One more insinuation like that and I'll have you removed. Reynolds doesn't flinch. I'm simply asking about a statistical anomaly in your court records, Your Honor. Public records show minority defendants receive an average of 43 minutes of court time, while white defendants average 17 minutes for comparable charges. Clear the courtroom, Harrison shouts, face mottled with rage. Everyone but essential personnel out! No one moves. The bailiff shifts uncomfortably, looking between Harrison and the growing number of official observers. Reynolds remains unruffled. I'd like to call Dr. Olivia Bennett to provide context regarding Ms. Davis's presence at the Grand Hotel. Before Harrison can object, Dr. Bennett approaches the witness stand. After being sworn in, she sits with perfect posture, credentials displayed prominently on the lanyard around her neck. Dr. Bennett, Reynolds begins, please explain the National Merit Scholarship Program, and specifically why Tiana Davis was at the Grand Hotel. The National Merit Scholarship Program identifies exceptional students from underrepresented communities, Bennett explains. Tiana Davis came to our attention through her extraordinary academic achievements despite limited resources. She maintains a 4.0 GPA while working part-time and volunteering at her community library, Harrison interrupts. This character testimony is irrelevant to the trespassing charge. It speaks directly to motive, Your Honor, Reynolds counters. Ms. Davis had legitimate business at that location, which negates the essential element of the trespassing charge. Bennett continues, "We conduct interviews at the Grand Hotel specifically because it provides a professional, neutral environment for evaluations. Candidates come from multiple districts." Harrison leans forward. "Why not meet at a school or public library? Why a luxury hotel?" "We want our candidates to feel valued," Bennett replies evenly. "Many come from neighborhoods where professional environments are limited. The hotel partnership demonstrates our commitment to treating these scholars with the same respect afforded to business executives." The prosecutor, sensing the shifting tide, stands. "Your Honor, in light of this new evidence, the state requests time to investigate these claims before proceeding." Harrison ignores him, fixating instead on Tiana, who sits with quiet dignity, her notebook open on the table before her. She continues to write, documenting every word of the proceedings. "Ms. Davis," Harrison snaps, "I've had enough of your note-taking. Hand over that notebook immediately." Reynolds stands. "Objection, Your Honor. Those notes constitute private attorney-client communications and work product." Harrison's patience shatters. "I want to see what she's writing about my courtroom." The admission hangs in the air, revealing Harrison's true concern. Not justice, but his reputation. Tiana looks up, meeting Harrison's gaze directly for the first time. The room falls silent, tension stretching between them like a wire about to snap. "Actually," Tiana says, her voice clear and steady, "I'm happy to explain exactly what I've been documenting, if you're prepared for everyone to hear it." The silence in the courtroom deepens. Harrison's momentary satisfaction at Tiana's apparent surrender quickly fades as he registers the confidence in her voice. "Proceed," he says, caution creeping into his tone. Tiana rises, standing straight-backed before the court. Gone is the intimidated teenager from earlier. In her place stands a young woman with purpose radiating from every inch of her slender frame. "For the past 7 months," she begins, "I've been tracking judicial misconduct across multiple courtrooms for a student research project on equal justice in our county's legal system." She opens her notebook, revealing meticulous charts, graphs, and dated entries. "What began as a school assignment evolved when I noticed disturbing patterns. Defendants of color consistently receive harsher sentences than white defendants for identical charges. Dismissal rates for white defendants are 78% higher. Court-appointed attorneys for minority defendants are given an average of 4.3 minutes to consult before proceedings, while attorneys for white defendants average 12.7 minutes. Harrison attempts to interrupt, but Reynolds raises his hand. "Your Honor, you specifically requested that Ms. Davis explain her documentation. Please allow her to finish." Tiana continues, her voice growing stronger. "I tracked 137 cases across 3 county courtrooms, including 42 in this courtroom specifically. The data shows systemic disparities that cannot be explained by case differences alone." She turns a page in her notebook. "Judge Harrison, in your courtroom specifically, black defendants receive sentences averaging 67% longer than white defendants for identical charges. You interrupt black defendants an average of 7.2 times per hearing, compared to 1.3 times for white defendants." Murmurs spread through the courtroom. Harrison pounds his gavel ineffectively. "This is preposterous. The ramblings of a child with no understanding of the justice system." Dr. Bennett stands. "Tiana Davis is not just any student, Your Honor. She's the youngest ever recipient of the State Youth Leadership Award, presented by Governor Chandler last year. Her research project on justice system disparities has been selected for national presentation at the Constitutional Rights Foundation's Youth Summit." Bennett approaches the bench, producing a folder. Her meeting at the Grand Hotel served 2 purposes: the scholarship interview and meeting with the hotel's corporate counsel about their community initiatives, which she's evaluating as potential models for judicial reform. The mysterious woman from the back row steps forward, badge prominently displayed. Director Samantha Williams, State Judicial Ethics Committee. Judge Harrison, we've been monitoring your courtroom after receiving multiple formal complaints about disparate treatment. Williams gestures to her colleagues. Our committee has reviewed Ms. Davis's preliminary findings and found them consistent with our own investigations. Her statistical methodology is remarkably sophisticated for someone her age. Harrison's face pales. This is an ambush. A setup. No, Your Honor, Williams replies calmly. This is accountability. Ms. Davis acted independently, but her documentation provides additional evidence for our ongoing investigation. Harrison attempts to regain control. None of this changes the fact that the defendant was trespassing at the Grand Hotel. Reynolds approaches with a tablet. Security footage from the Grand Hotel, Your Honor. It clearly shows Ms. Davis being escorted to the Oakwood conference room by hotel staff, exactly as she claimed. He plays the video. Tiana appears, presenting identification at the front desk. A staff member in a hotel uniform guides her toward the elevators. The timestamp matches exactly with the alleged trespassing incident. The trespassing allegation itself was false, Reynolds states firmly. Ms. Davis had permission to be on the premises, was there for legitimate business purposes, and was in an authorized area. Director Williams addresses the court directly. The Ethics Committee has been compiling evidence on Judge Harrison for months. We needed clear documentation of his behavior in court with multiple witnesses. Today's proceedings provided exactly that. Harrison looks around the courtroom, finally recognizing the trap that has closed around him. State officials line the back wall. Court reporters document every word. Several respected attorneys from major firms sit in observation. This is a witch hunt, he sputters. I've served on this bench for 20 years. Yes, Williams agrees. And during those 20 years, you've demonstrated a pattern of discriminatory behavior that undermines the fundamental principle of equal justice under law. She opens an official folder, extracting a document bearing the state seal. Judge William Harrison, by authority of the State Judicial Ethics Committee and the Supreme Court of this state, you are hereby suspended from the bench, effective immediately, pending a full investigation into judicial misconduct, abuse of power, and systematic discrimination in your courtroom. The gavel falls from Harrison's hand, hitting the bench with a dull thud that echoes through the suddenly silent courtroom. Within hours, the county courthouse transforms into a hive of urgent activity. In the main courtroom, Chief Judge Eleanor Michaels presides over an emergency hearing regarding Tiana's case. Her demeanor contrasts sharply with Harrison's, attentive, measured, and genuinely concerned. After reviewing the evidence, Judge Michaels announces, this court dismisses all charges against Tiana Davis with prejudice. The record will show these charges were without merit and improperly pursued. She looks directly at Tiana. Ms. Davis, on behalf of this court and our justice system, I extend a formal apology for your treatment today. What you experienced represents a failure of the principles we are sworn to uphold. Charles Whitfield, owner of the Grand Hotel, sits uncomfortably in the gallery. After the hearing, he approaches Tiana and her father. Ms. Davis, I want to personally apologize, he says, extending his hand. I spoke without full knowledge of the situation and contributed to this injustice. After learning about your research, I'd like to offer you an internship in our corporate social responsibility department. Your perspective would be invaluable. Across town at the Judicial Ethics Committee headquarters, Director Williams and her team begin the monumental task of reviewing Harrison's case history. Analysts pull digital records, while others compile physical documentation dating back years. The pattern is even clearer than we suspected, Williams tells her deputy, scrolling through a data visualization on her screen. Minority defendants received sentences averaging 60% longer than white defendants for identical charges. First-time white offenders received probation at 7 times the rate of minority offenders. A junior analyst enters with another report. Director, we've identified 23 cases with particularly egregious sentencing disparities. 3 defendants are still incarcerated despite circumstances nearly identical to white defendants who received probation. Williams nods grimly. Flag those for immediate review. Contact the public defender's office. We need to file motions for reconsideration. The media descends with predictable hunger. Initial headlines focus on the sensational. Teen turns tables on biased judge. And student researcher exposes courthouse corruption. A television crews camp outside the courthouse, competing for interviews with anyone connected to the case. By evening, more thoughtful coverage emerges. The State Tribune publishes an in-depth analysis titled Systemic Bias, When Those Who Judge Are Not Judged. Legal experts appear on news panels discussing the broader implications. What happened today represents both a failure and a success. Professor Elaine Montgomery, a judicial ethics expert, explains during a primetime interview. The failure is that a judge was allowed to demonstrate bias for years without consequence. The success is that finally, through the diligence of a remarkable young woman and proper oversight, accountability arrived. Tiana finds herself thrust into an unexpected spokesperson role. At a hastily arranged press conference, she stands beside Dr. Bennett, composed despite the forest of microphones before her. My research wasn't about targeting any individual, she explains carefully. It was about documenting patterns that affect real people's lives every day. One biased judge can impact thousands of families over a career. Her research, combined with the Ethics Committee's findings, provides compelling evidence for legislative action. State Senator James Parkman announces plans to introduce the Judicial Accountability Act the following week. Tiana receives an invitation to speak at the press conference announcing the bill. Ms. Davis's meticulous documentation provided the evidence we've needed, Parkman tells reporters. This legislation will establish independent review of sentencing patterns, mandatory bias training, and a more transparent process for judicial appointments. At the Grand Hotel's corporate headquarters, executives launch an internal investigation into how the miscommunication occurred. They discover that Whitfield's executive assistant, Gregory Palmer, deliberately failed to inform him about educational programs using their facilities. I didn't think those kinds of events belonged at our establishment, Palmer admits during his termination interview. They don't generate revenue and attract the wrong element. His dismissal is immediate, accompanied by a company-wide directive on the hotel's inclusion initiatives and non-discrimination policies. Harrison retreats to his Westlake mansion, doors locked against the media camped outside. He hires Julian Kraft, a high-profile defense attorney known for representing disgraced public officials. Judge Harrison's comments have been taken out of context, Kraft tells reporters from Harrison's driveway. His distinguished career speaks for itself. We are confident that a full and fair review will exonerate him from these politically motivated accusations. The statement backfires when the Ethics Committee releases transcripts of Harrison's courtroom remarks from multiple cases, revealing a consistent pattern of condescension and bias toward minority defendants. Even his political allies begin distancing themselves, their statements evolving from strong support to waiting for all the facts. Governor Chandler addresses the situation during a scheduled press conference. The integrity of our justice system depends on fairness and impartiality from every judge in every courtroom. My administration takes these allegations extremely seriously. We will follow the Ethics Committee's investigation closely and take appropriate action based on their findings. Behind closed doors, the governor's legal counsel reviews options for removing Harrison permanently if the investigation confirms the allegations. They also begin considering potential replacements, with an emphasis on candidates with demonstrated commitments to equal justice. The State Bar Association announces its own investigation into potential ethics violations by Harrison. Judicial misconduct of this nature, if confirmed, represents a serious breach of professional ethics, their statement reads. The Bar Association is committed to maintaining the highest standards of legal practice, including on the bench. Former defendants from Harrison's court begin coming forward with their stories. Community legal aid organizations establish a hotline for those who believe they received biased treatment. Within days, they record over 200 calls. Reynolds' law firm, Marshall & Reed, announces they will provide pro bono representation for appeals in the most egregious cases. Equal justice isn't just an ideal, Reynolds tells the press. It's a constitutional guarantee that must be enforced. Tiana returns to school the following Monday, attempting to resume normal life despite her newfound recognition. Classmates and teachers regard her with a mixture of admiration and curiosity. Her history teacher asks her to speak to the class about civic engagement and the justice system. Sometimes change starts with simply paying attention, she tells her peers, documenting what you see, speaking up when something isn't right. As the second week of investigations begins, a forensic audit of Harrison's communications reveals something even more damning. Emails between Harrison and certain prosecutors show coordination to target specific types of defendants, with explicit discussion of maintaining deterrent sentencing in problem communities. The Ethics Committee immediately forwards these communications to the State Attorney General's office, transforming the case from professional misconduct to potential criminal conspiracy. The State Judicial Center's largest hearing room reaches capacity an hour before proceedings begin. Television cameras line the back wall, their red lights blinking in silent witness. Security guards check credentials at every entrance. William Harrison enters through a side door, avoiding the media gauntlet outside. His expensive suit hangs slightly loose on his frame, evidence of weight lost during 2 sleepless weeks. Julian Kraft walks beside him, whispering last-minute advice. Gone is Harrison's imperious stride and confident smirk. He takes his seat at the respondent's table with uncharacteristic meekness, eyes downcast. The irony escapes no one. The judge now judged, sitting exactly where countless defendants once trembled before him. The 5-member Judicial Review Panel enters, led by Justice Rebecca Chen from the State Supreme Court. Their faces reveal nothing as they take their positions. This hearing will determine whether Judge William Harrison has violated the Judicial Code of Conduct and Constitution of this state, Justice Chen announces. These proceedings are not criminal in nature, but will establish whether Judge Harrison remains fit to serve on the bench. Director Williams presents the Ethics Committee's findings first. Evidence mounts in methodical, devastating sequence. Statistical analysis of Harrison's sentencing patterns, testimony from former defendants, court transcripts revealing disparate treatment, and the damning private communications. In this email, Williams highlights on the projection screen, Judge Harrison specifically instructs Prosecutor Phillips to seek maximum penalties for defendants from what he terms problem neighborhoods, while offering diversion programs for kids who made mistakes from good areas. Harrison's former clerk, Alexis Rodriguez, testifies about being instructed to schedule certain types of cases strategically. Judge Harrison wanted specific prosecutors assigned to cases involving minority defendants, she explains. He called it matching the right attorney to the right case, but it was clearly about ensuring harsher outcomes. As evidence accumulates, Harrison's defense strategy crumbles. Former allies abandon him one by one. Charles Whitfield, initially called as a character witness, instead provides a sworn statement about Harrison's previous comments regarding keeping undesirables away from establishments like the Grand. He told me during a golf game that strict sentencing was necessary to maintain property values and keep certain elements where they belong, Whitfield's statement reads. At the time, I didn't challenge these comments. That failure of moral courage is something I now deeply regret. Even more damaging, Assistant District Attorney Mark Phillips admits to feeling pressured by Harrison. There was an unspoken understanding, Phillips testifies. If you didn't pursue the sentences he wanted, your cases wouldn't be scheduled favorably. Young prosecutors who needed wins to advance their careers understood this clearly. As the second day of hearings concludes, Harrison requests permission to make a statement. Justice Chen grants his request, perhaps hoping for contrition. Harrison approaches the podium slowly. He begins with practiced humility, expressing regret for any misunderstandings and citing his 20 years of dedicated service. But as questioning from the panel intensifies, his veneer cracks. You don't understand the realities of maintaining order, he snaps when Justice Chen presses him about the email evidence. Someone has to make tough decisions to keep communities safe. And those tough decisions just happen to fall disproportionately on minority defendants? Justice Chen asks. Harrison's restraint finally shatters. Look at the statistics. Look at where the crime comes from. Someone needs to keep these communities in line or we all suffer. I was doing what needed to be done while the rest of you hide behind political correctness. A collective gasp ripples through the hearing room. Camera operators zoom in on Harrison's flushed face as he continues his tirade. You want to know the truth? Fine. Some people respond to second chances. Others only understand consequences. I gave each what they needed, and I make no apologies for it. The outburst confirms every allegation against him. Court reporters' fingers fly across keyboards, capturing every damning word. Within minutes, his statement trends across social media platforms, the unvarnished prejudice impossible to misinterpret. The panel deliberates for less than 2 hours before returning their unanimous decision. This panel finds that Judge William Harrison has egregiously violated the judicial code of conduct through demonstrated bias, abuse of power, and actions that have undermined public faith in our justice system, Justice Chen announces. We recommend his permanent removal from the bench and referral to the State Bar Association for disbarment proceedings. She continues, her voice firm. Additionally, we are referring our findings to the Attorney General's office for review of potential civil rights violations under state and federal law. Harrison sits motionless, the reality of his complete downfall finally sinking in. 20 years of power and prestige evaporated in 2 weeks. As Harrison shuffles from the hearing room in defeat, he freezes in the hallway. Tiana stands directly in his path, a documentary crew capturing the moment his eyes meet those of the young woman who catalyzed his downfall. 6 months pass, each bringing fresh waves of reform across the state's judicial landscape. The Harrison case, once headline news, has transformed into something more significant, a catalyst for systemic change. In the Capitol, Chief Justice Monroe addresses the annual judicial conference, hundreds of judges filling the auditorium. The integrity of our system depends not just on the letter of the law, but on its equal application, she declares. The Harrison case forced us to confront uncomfortable truths about implicit bias and institutional failure. The statewide audit of judicial conduct, launched in the wake of Harrison's removal, has identified 5 other judges with similar patterns of discriminatory sentencing. 2 resigned rather than face investigation. 3 others are contesting the findings, but their cases in court have been reassigned pending review. This isn't about punishing individual judges, explains Judicial Ethics Director Williams during a panel discussion at the State Bar Association. It's about healing a system that has lost the public's trust. Every biased ruling damages faith in justice itself. New requirements cascade through the system. All judges must now complete implicit bias training annually. Sentencing data is published quarterly, searchable by demographics to identify disparities. A citizen review panel adds community oversight to judicial appointments, ensuring diverse perspectives in evaluation. At the Grand Hotel, transformation takes a different form. The corporate headquarters has instituted comprehensive diversity and inclusion training for all staff. More significantly, they've established the Future Leaders Scholarship for underprivileged youth interested in hospitality management and business leadership. We're honored to have Ms. Davis serve as student advisor to our scholarship board, announces the hotel's new diversity officer during the program's launch. Her insight has been invaluable in creating opportunities that truly serve our community's needs. Tiana's research continues to expand, now supported by a grant from the State University's Department of Criminal Justice. She presents her findings at the National Conference on Judicial Reform, where her methodology is adopted as a model for community oversight of local courts. What makes Davis's approach so effective, explains Professor James Richardson, is that it provides quantifiable metrics for behaviors previously dismissed as subjective perception. When you can demonstrate that a judge interrupts minority defendants 400% more frequently than white defendants, bias becomes difficult to deny. The state legislature passes the Judicial Accountability Act with rare bipartisan support. Governor Chandler signs it in a ceremony where Tiana stands among the dignitaries. Key provisions include mandatory recording of all court proceedings, transparent sentencing guidelines, and an independent review process for complaints of judicial misconduct. This legislation ensures that what happened in Judge Harrison's courtroom never happens again, the governor declares. Equal justice under law isn't just a phrase we carve on courthouse walls, it's a promise we must keep. Former defendants from Harrison's court see tangible results from the reforms. A special review panel examines over 300 cases, resulting in dozens of overturned convictions and reduced sentences. A class action lawsuit against the county results in a settlement fund for those whose lives were derailed by Harrison's discriminatory practices. "I lost 3 years of my life for something a white kid got probation for," explains Marcus Turner, released after his sentence was reviewed. "I can't get that time back, but at least now people believe what we've been saying for years." Law schools across the state update their ethics curriculum to include the Harrison case as a cautionary example. Bar exam questions now test understanding of judicial bias and attorney obligations to report misconduct. As Tiana prepares for high school graduation, a letter arrives bearing the presidential seal, an invitation to join a special White House Commission on Criminal Justice Reform. 1 year after the fateful day in Harrison's courtroom, Tiana stands at the podium in Courtroom 3, now renamed the Equal Justice Chamber. Sunlight streams through tall windows, illuminating the diverse crowd gathered for Judge Amara Patterson's inauguration ceremony. "When I entered a courtroom last year," Tiana begins, "I couldn't have imagined standing here today. I simply wanted to document what I saw, to prove that the disparities in our justice system weren't just anecdotal, but measurable realities affecting real lives." Judge Patterson, a former public defender known for her commitment to fair treatment, smiles encouragingly from her position near the bench she will soon occupy. The wooden seat, once Harrison's throne of prejudice, has been replaced with a new design, slightly lower, facing the gallery directly rather than looming above it. "Justice isn't a concept that belongs to judges or lawyers," Tiana continues. "It belongs to all of us. And when it fails any of us, it fails all of us." Dr. Olivia Bennett approaches the podium after Tiana's speech, announcing an expansion of the National Merit Scholarship Program. "We've created a special track for students interested in legal and judicial reform," she explains. "Our first cohort includes young people from diverse backgrounds united by their passion for improving the system." The scholarship recipients stand for recognition. 20 students whose faces reflect the community's true diversity. Each wears a pin bearing the scales of justice, slightly tilted but in the process of rebalancing. The courthouse itself bears little resemblance to the intimidating institution of a year ago. Hallways display information about rights and resources in 8 languages. Community liaisons in bright blue vests help visitors navigate the court process. A monitor in the lobby displays the quarterly review of sentencing data, transparent for all to evaluate. "The building hasn't changed," James Davis observes to his daughter as they tour the renovated spaces. "But everything inside it has." William Harrison has faded from public view, his disbarment finalized after he chose not to contest the ethics violations. The civil penalties from class action lawsuits claimed most of his assets. Former colleagues who enabled his behavior have undergone mandatory retraining or been replaced. Mark Phillips, the prosecutor from Tiana's case, now works with the Ethics Committee, helping identify problematic patterns in other jurisdictions. "I was complicit through my silence," he admits during a training session for new prosecutors. "That's a burden I'll always carry." James Davis has found his own path forward, establishing a support network for parents whose children face court proceedings. "Navigating the system shouldn't require a law degree," he explains to a group of nervous parents gathered in a community center. "Knowledge is power, especially in a courtroom. Tiana herself stands at a crossroads of opportunity. Acceptance letters from prestigious universities cover her kitchen table, each offering full scholarships. She's decided to study law with a focus on judicial ethics and reform. Her original notebook, containing the observations that catalyzed systemic change, has been requested by the State Historical Society for their Civil Rights Archive. In her final act before leaving for university, Tiana visits her high school, speaking to students in the same classroom where her research project began. "I never set out to take down a judge or become an activist," she tells the attentive teenagers. "I simply documented what I saw consistently and meticulously. I stood firm when it would have been easier to back down." She holds up a new notebook, identical to her original one. "This is still my most powerful tool. Not because it contains anything special, but because it represents a commitment to truth, no matter how uncomfortable." The students lean forward as she delivers her final thought, words that will soon appear on posters in courthouses throughout the state. Justice isn't automatic. It requires vigilance, courage, and the willingness to stand firm when faced with injustice. If you found Tiana's story of courage and justice inspiring, don't forget to hit that like button and subscribe to PAP Stories for more powerful stories that spotlight systemic issues and the brave individuals who challenge them. Every subscription helps us continue sharing these important narratives that often go untold. Turn on notifications so you never miss our weekly uploads featuring people who stood up against discrimination and created lasting change. Join our community of justice advocates by commenting your thoughts below and sharing this video with anyone who needs to hear this message of accountability and hope.